Good morning. I'd like to call this meeting of the House Energy Committee to order. It is 11:04 a.m. Tabitha, will you please call the roll? Here. On leave? On leave. 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 Leave.
Here. Here.
On leave. Leave.
Here.
Leave. Online. Online.
Here.
Here. Here.
Present.
On leave. On leave.
Here.
On leave.
Here.
On leave. On leave.
Snuck in yet.
On leave.
Thank you, Tabitha. And thank you to our members, our testifiers, and all of our guests today for attending this public hearing on HB 502. It is a pleasure to be here. This bill, sponsored by Vice Chair Steele, would create a new state board to help streamline the siting of electricity generation and storage projects. Given our energy supply concerns and rising electricity costs, which impact all of our districts, I think this is important legislation, and I'm looking forward to today's testimony. Today we have several testifiers, so once again we are going to keep to a tight schedule of 6 minutes each. Testifiers. I know, that was pretty exciting. Testifiers, the members have all been sent your testimony, and your testimony is in their packets as well. Please use your time to summarize your written statements. Steve will raise a finger when you have 1 minute remaining. I'd ask the members to please hold any questions until all participants have had an opportunity to speak. We've arranged this to prioritize having time for members to ask questions, which is very important to me. Chair Causer, is there anything you would like to say before we call our first testifier?
I would, and thank you, Madam Chairwoman. This is an important issue, certainly one that we've heard from a lot of folks, particularly in local government. I've heard from a lot of local government officials on this topic, and I'm looking forward to the information presented. So thank you to all of our testifiers.
Thank you, Chair. First, Ms. Cross, would you please begin? Thank you for being with us.
There we go. I'm the Manager of Regulatory and Legislative Affairs with Reliability First. And Reliability First is one of the 6 NERC regional entities. NERC is the North American Electric Reliability Corporation, and together we have the responsibility of preserving and enhancing reliability, security, and resilience of the bulk electric system. And in December of each year, NERC publishes its long-term reliability assessment, which is a forward-looking assessment that examines the resource adequacy of the bulk power system over the next 10-year horizon. And the most recent report shows that much of the continent is at risk of resource adequacy shortfalls over the next 5 to 10 years. And specifically here in the PJM region, the risk level was raised last year from normal to elevated risk, meaning that energy shortfalls may occur in extreme weather conditions. And this increase in risk level was mainly due to three critical reliability trends facing industry right now, and that is load growth, managing generator retirements, and the need for new resources, both generation and transmission development. And right now, the rate at which the load is growing is higher than what we've seen in the last 2 decades. And compounding this challenge, further generation retirements are accelerating, and new generation and transmission is not being built fast enough to replace it. And while PJM's interconnection queue shows a significant amount of generation projects, many approved projects are not reaching completion. And this creates a critical timing gap that underscores the importance of building new resources quickly and delaying retirement of key generating units until those resources can be built. And I also want to note that many retiring generators are being replaced by variable resources like wind and solar, which do not provide a one-for-one replacement. So these resources depend on the weather and the time of day, which means we'll need more of them, more capacity, more storage to replace that traditional generation that is being retired. And as a result, the volume of projects entering PJM's interconnection queue has surged, creating a backlog. Recognizing this, the Federal Energy Regulatory Commission implemented FERC Order 2023 in November of 23 to streamline the interconnection process. And this process prioritizes shovel-ready projects, aims to reduce the backlog, and enhances transparency, providing developers with greater certainty and accelerating the path to construction. So for Pennsylvania, this means faster interconnection approvals, a more efficient queue, and a clearer path forward for new generation. Yet, although we're seeing greater investment and enhancements in the regional planning process, both generation and transmission development continues to be affected by siting and permitting challenges. And according to our data collected for our assessment, of the 1,100 transmission projects across the U.S. as a whole that are under construction or in planning, 68 of them, totaling 1,200 miles of new lines, are being delayed by siting and permitting issues. So we recognize that industry and policymakers must continue to address these persistent challenges of siting and permitting to ensure that these projects can be constructed. And we see many opposing views on the matter of siting. As an example, just a few weeks ago, the U.S. Supreme Court ruled to reverse a lower court decision to block an infrastructure project. And in this case, the Supreme Court is quoted as stating that the National Environmental Policy Act is a procedural cross-check and that the goal of the law is to inform agency decision-making and not paralyze it. However, others have expressed that policy is a means to consider impacts on communities and natural resources. And in some of our states, we see counties, communities, or local governments can greatly influence the siting process through formal participation and public input. And we're seeing that public opinion has blocked both transmission and generation projects. In fact, I recently read a reporter had been tracking rejections of wind and solar for more than 15 years, and that roughly 800 wind and solar projects across the U.S. have been rejected locally over that time frame. So we understand it's important not only to streamline the siting and permitting process by coordinating across agencies to reduce delays, but it's also important to improve community communications regarding the need for these projects and engage the public early on in the process to help reduce public opposition. And one strategy may be to align siting of new energy resources in areas where large loads are already interconnecting. And as I wrap up my comments here for you today, I want to leave you with this. We will need to rely on new generation and transmission resources to reliably operate the grid of the future. And this will include a mix of generation types, new technologies, and we'll need to build out transmission not only to connect that new generation on the system, but to increase transfer capability to support resource-constrained areas as generators continue to retire. And lastly, a reliable grid doesn't build itself. It's the result of intentional design and investments and policies that consider resource mix. Siting and permitting requirements can help us plan and engineer the grid of the future. And we look forward to continuing our collaboration with our states, reliability coordinators, and industry at large through this energy transition. So thank you for your time and opportunity to testify here today.
Thank you, Ms. Cross, and I appreciate you condensing your comments in the way that you did. We would like to hear from all of you and know that time is tight here in Harrisburg, so thank you for that. Next, we have Adam Walters, Senior Energy Advisor with the Pennsylvania Department of Community and Economic Development.
Thank you. Good morning, Chair Fiedler, Chair Causer, and members of the Pennsylvania House Energy Committee. My name is Adam Walters, Senior Energy Advisor for PA DCED. As the lead state agency on economic and community development, DCED understands the importance of energy to Pennsylvania's economy. We've had the pleasure of working with the Governor's Office and other state agencies recently to assist with the Commonwealth's first economic development strategy in nearly 2 decades. Unsurprisingly, energy was one of the 5 key sectors of focus in the plan, and we are continuing to leverage the Commonwealth's strengths in energy towards job growth throughout the Pennsylvania. But today I'm here to discuss with you all the Reliable Energy Siting and Electric Transition Board, known as RESET, which is one of the 6 components of the Governor's Lightning Plan. As a reminder, our power sector is undergoing extraordinary changes, and the need to bring new generation online has perhaps never been more acute. PJM's recent capacity market price increase of more than 800% portends a major supply-demand imbalance. The impact of this capacity market will be reflected on consumers' electric bills this month, June 1st to be specific. Luckily, the action taken by Governor Shapiro in the form of a complaint with the Federal Energy Regulatory Commission led to an agreement with PJM to keep prices steady over the next 2 years, but the longer-term threat to consumers, both businesses and residents alike, remains. And the Governor's, if we don't see new generating resources come onto the grid in the near term, we are going to see further price increases when the Governor's agreement expires in 2028. And the Governor's Lightning Plan, particularly the RESET Board, is designed to do just that. From coal to gas to nuclear energy, Pennsylvania has long led the nation as a pioneering producer of energy and a major builder of energy infrastructure, but today we risk falling behind. Too often, red tape makes it slower, more uncertain, and more expensive to build the next generation of energy projects in Pennsylvania. In fact, today, Pennsylvania is one of only 12 states in the nation that does not have statewide authority over siting for any key energy projects. Instead, it's a patchwork of local authorities with principal jurisdiction over projects of all types and sizes, no matter how important they are to the Commonwealth and how important they could be to the reliability of the grid as a whole. To fix this problem, HB 502, championed by Representative Steele alongside Senator Kaine with SB 502 in the Senate, establishes the RESET Board, a new technology-neutral, centralized, and streamlined process for developers building certain reliable energy generation and storage projects that will improve statewide grid reliability and lower electricity costs. The new optional process will help projects avoid delays and increase investor confidence that a project can get built in a reasonable amount of time. It will also continue to offer robust opportunities for local involvement in the siting process. The RESET Board will include 7 members, the Secretaries of DEP, DCED, L&I, the Chair of the Public Utility Commission, the Presidents of the Pennsylvania Chamber, the Building Trades, and the Chair of DEP's Environmental Justice Advisory Council, a cross-cutting selection of Pennsylvania business, environmental, energy, and labor communities. The board will be able to grant certificates of reliable energy supply for certain high-producing energy generation and high-capacity storage projects. It is important to note that RESET will never have authority over projects in residential areas. In other areas, local zoning ordinances and similar siting restrictions would be deemed satisfied when the certificate is issued. Before an application for a certificate may be submitted, HB 502 requires the project developer to consult with local elected officials and receive their feedback, providing the local municipality with an early opportunity to shape the project. Once an application is submitted, the board must hold a public hearing, providing other important opportunity for community feedback. Applications must include a wide range of information about the project, including information about the project's safety and reliability, why the site was chosen, and what the project's environmental impact will be. The board may only grant a certificate when the board finds that the developer has demonstrated that the project will comply with all state and federal laws, achieve all necessary permits, and not interfere with the region or municipality's orderly development. Application decisions will be made within 90 days in order to allow projects that receive approval to move forward quickly so that they can help address reliability needs and prevent consumer cost increases. HB 502 also establishes a new siting advisory council, which will make policy recommendations to the RESET Board and advise on the public participation component. The Siting Advisory Council will include the Consumer Advocate of the Commonwealth and the executive directors of the County Commissioners Association of Pennsylvania, the Pennsylvania Municipal League, Pennsylvania State Association of Township Supervisors, Pennsylvania Farm Bureau, and the Pennsylvania Game Commission. These members with diverse expertise in energy, local government, land use planning, and environmental protection will help the Reset Board make sure that all voices are heard throughout the process. In comparison with proposals that had similar goals in prior legislative sessions, we believe the Reset Board provides better protections for communities and natural areas, greater transparency, and a much more robust set of opportunities for community input. It does all this while making the requirements clear and the timelines faster. In all, it's a much-needed tool to get steel in the ground. It will speed up siting and permitting decisions, cut red tape, and ensure that the next generation of all of the above energy projects are built today in Pennsylvania. Thank you for the opportunity to discuss this critical part of the Governor's Lightning Plan. We appreciate Representative Steele and Senator Kane's leadership on this issue, and we look forward to working with our partners in the General Assembly to ensure Pennsylvania is positioned to lead the way in clean, reliable, and affordable energy for years to come.
Thank you, Mr. Walters, for your testimony and for being here today. Next, we have two speakers who I understand are going to share the 6 minutes, so thank you for that. Thomas Petrucci, Manager, South Whitehall Township in Lehigh County, and Brian Rengert, Director of Government Relations with the Pennsylvania State Association of Township Supervisors. Thank you both for being here.
Thank you, Chairman Fiedler and members of the House Energy Committee. My name is Brian Rengert. I am the Director of Government Relations for PSATS. So on behalf of our 1,400 members across the state, we appreciate the opportunity to comment on this legislation. And as mentioned, I have Tom Petrucci, manager from South Whitehall Township, to provide a little bit of local government perspective as well. I think we all agree that Pennsylvania should be an energy leader and that when the state succeeds, our local governments also succeed. However, local governments are not the ones holding the state back, and we oppose House Bill 502. Local government's role in land use decisions is meant to be a balance of wishes of the residents as well as the wants of developers. It is not a responsibility that our members take lightly, and it is heavily governed by the Municipal Planning Code. If a municipality has zoning, they must plan and allow for every use, and there are very strict timelines a municipality must meet. Energy generation and demand is rapidly developing issue, with nearly daily developments. Due to federal permitting delays, supply chain challenges, state permitting process, and construction delays, the new and upgraded facilities and development can't keep up with demand. In Pennsylvania, the growth of grid-scale solar facilities has exploded over the last 5 years. Reminiscent of the recent natural gas boom, Pennsylvania's municipalities are at the forefront of the solar discussion. Our members were quick to understand the impact solar facilities would have on their communities, both now and in the future, and plan accordingly. I think it's important to note that municipalities can plan for energy facilities, but like any allowable use, municipalities cannot stop or keep them out. House Bill 502 removes an important check and balance from the development process by local elected officials who understand the uniqueness of their communities. It overrides the careful planning performed by local governments and strips communities of the protections offered in the MPC. Some specific concerns about House Bill 502 are the required attempt to consult with the host municipality appears to be nothing more than checking a box. The required public hearing does not need to be in the host municipality and limits a resident's participation. Township officials, again, cannot deny a project just because there is public opposition, but they can work with both residents and developers to try and find common ground. Additional questions: how will the board proactively plan for and mitigate impacts on residents? What standards will the board adopt so that developers know what is expected? Once approved by the board, House Bill 502 would prohibit the municipality from requiring any further approvals or permits or have any other oversight that could be seen as delaying the plan. How will the board ensure that the development is in compliance with the plan adopted? Municipalities administer and enforce many state laws through the land use process, including stormwater, sewage, floodplain requirements, and construction standards. If the municipality is removed from the process, how will the new board ensure these plans are in place and that they are being followed once the site preparation begins? The MPC gives municipalities the authority to plan for growth in their communities. I'll now turn it over to Tom to provide a little bit of the local government perspective.
Thank you. So I have served as a municipal manager of 3 different types of communities: a small borough, a rural township, as well as a suburban township, which is South Whitehall, where I'm at now in Lehigh County. So each of those communities had their own unique makeup and set of characteristics, and that helped the local officials to inform local planning and land development decisions. So that's indicative of all communities across the Commonwealth. So I've come to understand and appreciate that no one knows their community better than those who were elected by their own residents to make those types of decisions. So as noted earlier, I think we all recognize that there's a need for electric and energy facilities across the Commonwealth. But what is really needed is guidance for those municipalities that are impacted, not a mandated regulation that essentially cuts the municipal officials out of the process. So respectfully, any guidance that the state can provide should allow municipalities to address state concerns at a local level. And then community leaders and officials in each of the municipalities could then provide input and oversight to where such facilities could be located from a site suitability standpoint as applicable and in accordance with the existing regulations as provided for in the municipality's planning code. So there are many different types of communities in the Commonwealth, as noted. There's no one-size-fits-all to zoning. However, it's important to note that municipalities must provide for every use in accordance with the municipality's planning code. But what officials attempt to do is incorporate those uses into the fabric of their existing communities. So, for example, you would not want to build a 4-story apartment building next to a single-family neighborhood. Similarly, you would not want to put a large-scale energy facility in the middle of contiguous farming parcels in a rural township, which may have 3,000 or more acres of preserved open space, which was provided for in Commonwealth funds in many cases. So in those instances where you're not citing things properly in accordance with the existing land use, you could effectively cut off farming uses. So in South Whitehall Township right now, we've undertaken a very significant planning project to provide for an overlay zoning amendment. So just for an example of that, we're looking at industrial uses, residential uses, and providing incentives to developers, working in collaboration with developers and stakeholders to make sure we have a successful outcome. So as part of that, though, it also looks at buffering, screening, setbacks, architectural requirements, all things that this proposed legislation does not account for, which local and municipal officials must account for. So it's problematic to plan in a vacuum without accounting for traffic, utilities, and site locations. We as local municipal officials must account for all of those, for transportation, for wastewater, for public drinking water, for open space and recreation. All must be accounted for in accordance with previous planning efforts. So in summary, when local officials are not consulted in the process, they would be then left to deal with the impacts, and their residents rely on them to guide them when they are facing challenges. And in this case, we would not have had the opportunity to guide what the outcome would be, but still have to deal with the aftermath. So thank you for your time today.
Thank you both. Our final testifier for the day is Mr. Ron Grutza, Pennsylvania State Association of Boroughs.
Thank you, Chair Fiedler. Thank you, Chairman Causer and members of the House Energy Committee. My name is Ron Grutza, Senior Director of Government Affairs for the Pennsylvania State Association of Boroughs. You have my testimony. I'll just hit some of the highlights. I think PSATS did an excellent job of laying out a lot of similar concerns that we have with the legislation. The Pennsylvania State Association of Boroughs is a nonprofit, nonpartisan governmental association, which we represent over 900 borough communities and thousands of elected and appointed officials throughout the Commonwealth. We do recognize some of the energy challenges which were already laid out by earlier testifiers, and we of course want to work with the General Assembly and in enacting smart legislation which would combat the higher demand and the higher prices to get more supply into the system. We want to commend Governor Shapiro for putting forth the Lightning Plan, and of course Chair Steele for introducing the legislation to start the conversation here in this component of the Lightning Plan. Pennsylvania State Association of Boroughs, we do oppose House Bill 502 in its current form. Specifically the usurpation of local land use decisions at the local level. I will point out that the County Commissioners Association, the Pennsylvania Municipal League, the Township Commissioners Association have all submitted written testimony, which you have outlining their concerns. I would highly recommend that you take that into consideration as well. But House Bill 502 really, at PSAB, we look at everything through our guiding principles, which is to allow our members and local governments in general to have the most flexible powers that would allow them to decide what is best for their own community. And we think that House Bill 502 would usurp local decisions and local democracy. Local leaders are best equipped to make those decisions with the approval of the projects which they and their constituents are going to have to live with. Our members have spent a lot of money and a lot of time enacting common sense land use ordinances and comprehensive plans in their communities. And the developments have to, as was mentioned earlier by Mr. Petrucci, stormwater and of course, how the developments are going to impact traffic patterns. Would all these things be preempted by a reset board? We think that that is problematic and that we need to keep decisions locally. Now, notwithstanding our opposition to the concept of the reset board, we do have concerns on the process of the reset board. There's no representation of local government officials on the actual reset board. We do appreciate the advisory board that is acknowledged, but no local government representation on the reset board. So we think that that is troubling. And what was mentioned earlier is that the public hearings are not required to be in the municipality. We think that that's an oversight. And also, really, there's no real clear standards for approval of these plans. Notwithstanding, of course, all the concerns that our association has with the legislation, we are very happy to work with the committee, the administration, and the General Assembly at maybe looking at a streamlined process which keeps the process local while also streamlining some of the approval deadlines for large energy generating projects. We'd be happy to work on that. In fact, we've worked with other industries, Act 191 of 2012, the co-location of broadband facilities, Act 50 in 2021, the Small Wireless Deployment Act. We also are very happy to work on model ordinances if that is something that you want to put in the legislation as well. So just to close, we ask you to please consider these concerns that we have with the legislation, and we would be very happy to work with you on any other changes to it. Thank you very much for your time, and be happy to answer any questions.
Thank you so much. Our goal with this committee, as I mentioned in the beginning, is to thoroughly vet legislation and to hear from a variety of stakeholders. I think you see that here today, and we'll continue to hear that in the hearings that we are having on this bill. Thank you to all of you for joining us. I do want to recognize that joining us as well online is Representative Williams. In person, joining us, Representatives Stambaugh, McAndrew, Inglis, and Rusnock. This is obviously a piece of the governor's energy plan, and so I'm going to ask one question. I'll ask members if they can think of their questions during this time. We'll do our best to keep them condensed so everyone has a shot to ask from our panelists. But Mr. Walters, my question will be for you. Could you explain to us how the administration decided who would be on this board? And could you also talk about whether this bill forces developers to apply to the reset board?
I'm going to take the second question first. No, this is better. No, this is not necessarily a requirement, right? It is not something that developers are required to go through. It is an optional step. It's an additional tool in the toolbox that developers will ultimately have access to. I think we recognize and honor the role of local government in Pennsylvania, given the storied history that we have of decentralized decision making. And again, this is not something that is a requirement. It is an optional and an additional tool in the energy and economic development toolbox. In terms of how we went about going about the process of deciding who was on the board, I mean, I think if you take a look at the construction of the board, we wanted to make sure that we had a really well-balanced cross-section of folks from different parts of the economy. We also wanted to make sure that that the individuals had, a really good statewide lens through which they see a lot of these issues. You see that with the Pennsylvania Chamber and the secretaries of individual state agencies, as well as the Public Utility Commission. This is an issue that is statewide in nature in terms of its scope and the problems that it poses for Pennsylvania. And we wanted to make sure that the board was comprised of folks that took these and were able to address issues at that altitude.
Thank you. And also just to clarify, approval from the Reset Board would not negate a developer's need to get, for example, environmental permits, stormwater permits, other permits as needed.
Correct. It doesn't negate the requirement for any permits. It just sort of brings together and streamlines the procedural elements of putting those permits together and getting them approved in a much faster timeline.
Thank you. Thank you for that. I have heard the concerns about the membership of the board as expressed from here and from others in the room and elsewhere, as well as questions about the requirements on the locations of the public hearings. And I think those are two areas that I look forward to further discussion on. Chair Causer?
Thank you very much, Chair Fiedler. And, my question deals with the process and with the board and board itself. We've heard a lot today about stability, predictability, cutting through red tape, which many of us here have worked toward those issues for many, many years. But at the same time, we want to make sure that local officials are involved in making the decisions on what's going on in their community, because they obviously know way better than the state does. I'm interested if any of our testifiers know, since it was stated early on that other states have boards like this, are other states are they functioning the same way that this bill would propose? Is there a difference to how they function? Do they streamline state permits while leaving local authority intact? Do any of you know that?
I can't speak to that specifically. I can say, reading through some of the other testimony that was submitted, I believe they do point out how some of the other states operate. But I think Chairman Causer, you commented on something that I did not have a chance to bring up in my testimony, but is in the written testimony, that our position is that that is something that we should look at from the state level. Local government. Their process is laid out in the MPC very clearly. Our timelines, what we are and are not allowed to do. And the governor has done a great job in streamlining a lot of permits across the state. But we think there should maybe be a bigger focus on some of the permits at the state and federal level, because that probably is really where the holdup is.
It just seems to me that, maybe there's an opportunity to streamline, as you stated, the state permits and try to get our act together at the state level while leaving intact that local government decision-making, because, as I said before, we want local government to be making these decisions. They know the area, they know the issues, and I think that local control and local input is vitally important, more than just having a public hearing, because we all know how that can go. And so I think that we need to take a closer look on what other states are doing with boards like this and consider that local input. So, thank you, Madam Chair.
Thank you, Chair Causer. We have 6 members with questions, 3 Ds and 3 Rs. So we will start with Vice Chair Steele, who is online.
Thank you, Chairwoman, for allowing me a quick question here, and also for your guidance and support on this important bill. When I read through the governor's lightning plan, this bill is the one that really caught my eye, and I petitioned to be the prime sponsor. I do believe this may be one of the most significant pieces of clean, reliable energy legislation that we will work on. I think it's also a massive protective factor against rising costs for consumers. Both are things that we should be focused on and are focused on. It's also an all of the above bill, which will cement Pennsylvania's future as a dominant energy leader. Mr. Walters, as you've said, the need to bring on more energy projects has never been more acute in Pennsylvania. And so I want to clarify something, Mr. Walters. And I'm asking this as a former borough council member and also the chair of my own community's comprehensive plan. So I've got a lot of experience at the local level, and I want to delve into this preemption issue a bit further. Would this legislation allow the developers to pursue projects without consulting with the local community?
The short answer to that is a resounding no. It would not allow them to do that. As I noted earlier, we very much honor the role of local communities and municipalities in Pennsylvania, and I think that you'll see that reflected in the language of HB and SB 502. The process for a developer receiving a reliable certificate begins with and is critically dependent on the engagement that they undertake, meaningful engagement that they undertake with local communities at the beginning and throughout the process at multiple stages. The board will take that into consideration and ask for that to be part of the record when a certificate is sought. And so, again, just kind of circling back and saying, no, it does not provide the ability to circumvent or avoid meaningful engagement with local communities.
Thank you.
Thank you. Next, we have Representative Barton.
Thank you, Madam Chair. And thank you all testifiers. I think we hear reliability, reliability, reliability. Every one of you used that word at one point. Our the prime sponsor just mentioned it right off the bat as well, too. My concern is that the definition of reliable energy facility doesn't have anything to do with the energy actually being reliable. It only requires the facility to produce 25 megawatts or more of a power to modify the existing power generation facility to bring it over 25 megawatts. If we're talking about reliability, and my question is, bear with me here, the capacity factor is probably something you're familiar with, is the measure of how energy actually is produced relative to the potential capacity. Simpler. Capacity factor is the percentage of the time you're at your rated capacity. Simpler. Capacity factor is reliability. According to the Department of Energy, nuclear is going to be at about 92.5%. Solar is going to be under 25%. If we're talking about a reliable energy generating facility, shouldn't we include capacity factor and probably accountability factor, availability factor also? Any thoughts on that?
Sure, I could start with that one. Great question. And so what we really focus on at Reliability First is a reliable and secure bulk electric system. And what we recognize is that there is no one perfect resource, and we will need a mix of these resources as we move to the grid of the future. And that is why it's so important that we are able to construct new resources to replace that generation that is being retired, and also to build resources needed to support the unprecedented load that we see coming on the system right now. And so when we talk about what's a reliable resource, we look at resources as a whole, making sure we have the right balance, the right mix, because we can go into pros and cons of each of them. And it's really about making sure that we have what we call essential reliability services, those services that we need to balance and support both voltage and frequency and inertia on the system itself. And so we look at it more as in a holistic approach that as long as we have the right mix on the system, we can support a reliable grid.
Right. And I think we need to make sure that we're including all energy sources as an opportunity here.
That's right.
And it's important that if we look at
mix.
availability factors, the percentage of time that a system's online, I'd be curious what any solar field availability factor was for the month of May.
Yeah, and I don't have that number off the top of my head, but
I'm not, yeah.
PJM has they call ELCC, which is very similar to what you're describing. It's their accreditation process, and I think right now solar is around that 14% range. So it's definitely something, and that's why I said in my testimony we need more of them to replace the existing generation that's being retired.
Thank you.
Thank you.
Thank you. Representative Venkat online.
Thank you, Chair Fiedler. My question is for all the panelists. Listening, I'm sympathetic to both the concern about impeding the siting of important energy projects, but also taking away local control or not having enough local input. My question, and this may be outside the box, has there been any thought to add a member of the local municipality government to the reset board for projects that are involved in their community so that they do have a voting voice on the reset board, but not an overwhelming voice that might be able to stop consideration, but they would be more actively part of this. So is this something the administration has considered? Is this something that the municipal organizations have considered? And would they view that as something that would be beneficial?
I think I would go back to a comment that I made earlier about the fact that the issue that an unreliable grid presents to Pennsylvania businesses, consumers, everyone that has to pay an electric bill is one that is truly statewide in nature. And if you look at the role that Pennsylvania plays in PJM and perhaps, quite frankly, being the power plant for much of the eastern seaboard, that's an issue that has ripple effects that go well beyond the state's borders. And so not saying no to the opportunity to consider, additional ideas for, the contours that this legislation could ultimately include. But what we wanted to create was a construct, and I talked about the altitude at which the members of the board sort of see these issues in Pennsylvania, which is very much statewide. And we want to make sure that the solution is one that is meeting the problem where it is, which is at a very high level with very, very critical elements that play throughout the entire state and beyond.
Representative, thank you very much for that comment or that question. I will, as you said, I do think it's an outside the box idea, so it is not something that we have thought about. But we are certainly definitely interested in finding ways for the municipality to be more inclusive as well as residents. So certainly would welcome further discussion with you on ways to do that. It could be difficult. I will just add that this means the board will be changing. It would be essentially one member would be changing on the board every time, but I'll let other people think about that.
Sounds like a complex negotiation. Thank you. Chairwoman Rapp.
Thank you, Madam Chair, and thank you, gentlemen and ma'am, for being here today to testify. I share some of the same concerns as my colleagues. Especially taking away local control. I see that as a huge barrier for me to be able to support this bill at all. But there are some other factors as well. I look at this bill and some of the definition as far as reliable energy. We are an energy-rich state. Pennsylvania has been blessed with almost endless natural gas, oil, coal since the 1800s and probably before that. And I think it's a sad situation in Pennsylvania because when I look at this bill, go down through it, trying to summarize it, this, in my opinion, is definitely nothing but a big pitch for solar, which can take up massive amounts of land, including farmland. And I have brought this issue up before. I've had a bill for several years, the decommissioning of solar. And I understand that there might be a bill forthcoming from the Senate as far as decommissioning, but right now that doesn't exist. So when we are considering putting acres and acres of land into solar panels, there is still no state position on how, at the end of the day, all of that will be decommissioned, whether it's ruined by a hailstorm, lightning storm, or whatever kind of disaster, who at the end of the day, if the municipality can't weigh in, is going to clean up the big mess at the end of the day when it all reaches the end of their life cycle. But I do see this bill not as a real reliable energy bill, but I see this as a big push by the administration for more solar in this state because I do not believe this administration supports fossil fuels. The permitting process has been a disaster for many of our locals, especially in Northwest PA and in the oil and natural gas field, and we all know what's happening to coal. Even if you go down to Virginia and go to the port and see at least a quarter mile of coal cars sitting there for coal to be exported to China and Vietnam and all over the world, but not utilized here. So I have a lot of concerns about the bill. I would, at this point, definitely be a no. And if this, in reality, is nothing but a big push for more solar, wind, I'm even more of a no, especially with no plan at the end of the day for decommissioning. So that's where I stand, especially when we can't seem to support fossil fuels in this state. Natural gas is still one of the cleanest energy products that we have, and Pennsylvania has been blessed, deeply blessed, for this energy resource. So, but I thank you for your testimony. I am thankful to have the folks here, defending the municipalities. I think it is wrong for the state to try to take that authority away. So I appreciate your testimony today. And I would definitely, at this point, be a no on this legislation. Thank you.
Thank you. Representative Pielli?
Thank you, Madam Chair, and thank you to all the testifiers. Following up on what was just said by my colleague, I'm very sensitive to local concerns, having been a township supervisor, and my fear, or my concerns, I should say, weren't so much that it was a pitch for solar or wind, which we are like 49th and 48th in the state. We have big gas and oil producers like Texas who are #1 in natural gas, and yet they're #1 and 2 in wind and solar. The whole idea is all of the above, and we need to diversify. Texas gets it, and if we're going to be a big player, we have to get it too. My concern is not so much of preempting local authorities for solar, although it should be considered based on what you were saying. But we've had the unfortunate experience of having the Mariner pipeline come through our district. And we had some terrible repercussions with well water and drinking water. And my concern is that it would be preemption. It turns out that Mariner ended up getting a public utility status, which I don't even want to get into. We challenged that, and to this day I think we were right and they were wrong. They're not a public utility. But nonetheless, they were able to put that pipeline down. The geological impact, we're still suffering. There was a whole neighborhood that was basically bought out by them. They had to eventually do that because they couldn't keep supplying bottled water. So I'm very concerned about the preemption in that regard. At the same time, I understand the greater good, where we have to look at the greater good for the entire state. So I'm very aware of that. But following up on my colleague, Representative Venkat's idea, he took the words out of my mouth. I think the two big issues with this bill that people seem to have a very big concern with is preemption and the makeup of the board. And so I would submit to all of you the question, would it be something that would make the legislation more palatable to everyone, not expecting everyone to be totally happy with it, but if they did have representation of a local member from the local community be appointed. So you would have your reset board, but depending on where you go, what locality, there would be someone appointed from the local government, be it a county, be it a township, be it a borough, whatever the case may be, that would be appointed and would have a voice. And this way you would actually have a voice. Because, you know, consulting doesn't necessarily mean complying with the local wishes and the local histories. And if you look at the example I just cited, something like this could happen again. So at the very least, I think that the local authorities do deserve a voice on that reset board. So I just submit that to you and ask for any feedback within the limited time we have. Thank you.
I appreciate that, and I think we do have great concern with the kind of the feedback or the amount of feedback that is called for under this bill. That, as I said in my comments, it's more of a check the box. I don't have the bill in front of me, so I forget the exact language, but it says shall use their best effort or something along those lines. And in addition to the MPC, we also have a number of sunshine regulations and that we have to follow. So if a three board member board of supervisors wants to meet with the developer, they would potentially have to sunshine that, have it as a public meeting, so they're not violating the sunshine law, which would take additional time, but it's not additional time because of them, it's additional time to be open and transparent. So as I said earlier, I mean, we welcome the conversation of figuring out ways to have more municipal participation in this legislation.
Representative, we would still have concerns with usurping the local decision-making process, but I think it's definitely a step in the right direction.
Yeah, I would just add that the criteria for selecting the person should be well-defined, and who would be involved with the appointment.
Thank you. And also would like to recognize that joining us is Representative Kale. Representative, thank you for being here, and I understand you have a question.
I do. Thank you, Madam Chair. Forgive my tardiness. Sometimes the turnpike is unpredictable on your way from Beaver County into Harrisburg. Very briefly, I have a question regarding the constitutionality of such a proposal. My understanding was when the natural gas regulations came into play, there was some issues with local preemption and the state not being able to dictate to local jurisdictions basically certain zoning and regulatory issues. Would that not come into play here? How are we getting around that? What's different about this as opposed to that?
I mean, the constitutionality, notwithstanding, I'm not an attorney or a scholar of that topic in particular, but I think that the way it's constructed isn't to throw out or eliminate any of those elements, right? It's to streamline, bring together, cut red tape, make the process faster, more efficient, more responsive, quite frankly, to what we're hearing for calls in the market for bringing power generation online at a faster rate. And the need to do so, as I think is evidenced by the comments that I made and that everyone else made, is very real. So again, it's not an attempt to eliminate any of the individual components that are required to bring an energy generation project online. It's just a matter of where there's a lot of Venn diagram overlap, for example, bringing it together and making it move more responsive to the needs of business.
Just to say I'm not an attorney, but internally we have had some discussions about that of how is this different and is there a constitutionality question, but I do not have an answer for you at this time.
Thank you. Representative Armanini.
Thank you, Chair Fiedler. If I could ask, with this bill and the board that's going to be brought on, from the original comments, the shortfalls, the load growth that we're experiencing, the retirement of facilities, and the new generations of energy that we want to bring on, how does this bill help those three aspects that you mentioned? To me, this just bogs things down more because we're making another committee that we have to sit through in Pennsylvania before we can do things.
Well, I think it helps in a number of different ways, but primarily what I was, just speaking to a moment ago, which is streamlining an otherwise more networked set of processes and procedures that are required in the business as usual case, right? I mean, it makes things move faster. There are, strict requirements on the timing for being able to issue a certificate. And I think that's something that we're hearing from, and just my perch at DCED is hearing from a lot from developers that there a lot of developers are ready to build a variety of different types of energy projects in Pennsylvania right now, and it's a matter of how do we accommodate that. And we believe that this bill is again a tool that helps to move forward that and to accommodate much needed energy generation projects.
Okay, I can understand that, and having to agree with Chair Rapp with this does definitely sway toward our renewables. This is a thing that one really concerns me. We have the state of Ohio right beside us, who right now have over a dozen new or in-process gas-fired energy facilities being built, which is going to generate over 9,700 megawatts. And here we are talking about a little 25-megawatt energy facility. We are losing in the energy game. We are the #1 leader of the cleanest natural gas underneath our feet. And we should be moving so fast at the speed of lightning to get more of these facilities up and running. We have 0 in Pennsylvania started. We all talk of energy, but we're leaving out the energy that can keep us the leader. And until people realize this, we are never going to win. We cannot bring in the mega data centers that come in and build without any government required money, because we cannot use what God has given us under the ground in Pennsylvania. So this is really what we need to look at. And I may be a little bit off key from what this bill is for, but until we utilize natural gas in Pennsylvania, consumers, your price of electricity is going to go up. Because I would really like to see the data of the solar and wind facilities that are in process. What are they truly generating? I know the month of May was not good for solar. So, let's really get the facts. And if federally funded money went away from solar, how would that industry come on by themselves to generate energy and to move forward? So any comments, on that? We're really missing out on the use of natural gas in Pennsylvania, and it's a shame.
Well, there's a lot to unpack there. The one thing that I would respectfully push back a little bit on is that this legislation, well, two things. A, is very much fuel and technology agnostic. It's clearly written in the language of the bill, and it's something that I think very obviously reflects the governor's all of the above energy policy. So this is not something that is geared towards one particular type of energy resource or type of energy development. And I think that's reflected in the language of the legislation.
Thank you.
But it does not correct the problem of Pennsylvania losing out as being the energy supplier of northeast of our country. Because you're never going to do that with the renewables that he's specifying in here, because they have offended the natural gas going back to the Wolf administration. Again, as I mentioned, we have zero natural gas energy facilities being built in Pennsylvania. Ohio has 12.
I think
he lost again. He lost again.
I think one of the ways in which we're potentially setting ourselves up to lose out to competitive states in the energy space is without one of these statewide siting authorities. We're one of only 12 states in the country that doesn't have one. We have them in Ohio. We have them in, which you noted, we have them in New York. And so this is, something that's been deployed successfully in a lot of surrounding states. And it's one way that we can actually catch up and do a better job of winning rather than losing.
Right, and we
Thank you,
never
Mr.
should,
Walters.
and we
Thank you,
never should have had to
Representative.
catch up. We should have maintained our leadership. Thank you so much.
Thank you. I do have more questions. I know members have questions. Stay tuned. We have another hearing on Wednesday. I do think this legislation requires a delicate balance that includes both making sure we are producing energy and we are including the voices, and truly including, not just listening, but actually including the voices and feedback of local residents. So stay tuned on that. Thank you very much all for being here. Any closing comments, Mr. Chair?
Thank you, Madam Chair. There's obviously a lot of concerns with the bill, and I want to thank our testifiers for being here today. Thank you.
Thank you. It is 12:05. This meeting is adjourned. Thank you.